Court of Appeal in and for the 5th District of the State of Florida is now in session. The Honorable Joseph Boatwright, Judge, presiding. All persons have business before this court draw near. Give attention, you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good morning. Welcome to the 5th District Court of Appeal oral arguments located this morning in Citrus County. Thank you very much for having us today. Before we get started, let me introduce the judges on the panel. I am Judge Boatwright. To my right is Judge John Harris, and to my left is Judge Paige Kilbane. I do know we have some school groups with us this morning, so thank you for being here, and we will try to leave some time for you to ask questions after we get finished this morning. Also, as a preliminary matter, if you could silence your cell phone or any other device that you have at this time, that would be greatly appreciated. We have 2 cases on the docket this morning. Each side will have 20 minutes to make their argument. Appellant is allowed time for rebuttal argument, and so when you come forward, please let us know how much time you would like for rebuttal. And so the first case we have on the docket this morning is case number 2024-1530, Salvador Carranza versus the State of Florida. Is the appellant ready?
Yes, sir. Please court Robert Berry on behalf of Mr. Carranza. Before I begin, I just wanted to say how happy I was to see that this was being done in Inverness, Florida. My grandparents moved from West Virginia down here back in the late 60s and spent the rest of their days here. Spent many happy hours in this little town, caught my first fish here. And with that, on to Mr. Carranza. This is a...
Would you like to reserve any time?
Oh, I'm sorry. I would. 5 minutes, please.
Okay, thank you.
I appreciate that, sir. This seems to be a case where the defense attorney made sort of a classic defense move, which is to rely on the charge that was brought by the state as drafted and sworn to by an assistant state attorney that they are instituting it in good faith. And the accusation as written is that Mr. Carranza knowingly possessed and manufactured, delivered heroin, and then was caught with heroin. The evidence at trial was that Mr. Carranza was interrogated for quite a long time, steadfastly maintained that he had possessed cocaine. That was his understanding from what was...
What was actually the evidence at trial that he knew it was cocaine? I thought I read the opening statement. Defense counsel originally argued that he didn't know what was in the boots, and then they put on, was it just his statement? Was that his recorded statement that said it was always cocaine? Is that the statement you're relying on?
Yes, sir. The opening statement by the defense is, whereas I credit her with her, attacking the charge as delivered, was sort of a vanilla opening statement. She really didn't say much of anything, and which is something that defense attorneys do for some reason. I don't really understand it. The better practice probably would have been to announce that this is the defense. He's charged with knowing it was heroin, didn't know it was heroin, and proceed from there. But in any event, the defense presented their case, relies mostly on the defendant's own statement, which he never seemed to deviate from. The state doesn't believe in, which is an argument they can make to the jury, but there was no evidence that he actually knew that he had possessed black tar heroin. And as charged, it's a valid defense. If the state wanted to pursue the theory they actually ended up pursuing at trial, what they could have done was charge it that way. They could have charged a count 1, which is what they wrote, which is, we don't believe that he thought it was cocaine. This is just some, excuse. Or, in the alternative, we're charging him with believing he was possessing cocaine, but under 2A of 893-135, or 032A, he's accountable for whatever he possesses, regardless of whether he thought it was cocaine or marijuana or fentanyl or whatever.
Well, doesn't that take care of your argument? That point under subsection 2, did the legislature just address this issue?
it would take care of it if they charged it that way. And that's the here I think that the defense attorney was attempting to, but there's an alternative theory that she didn't know about that statute at all and was caught flat-footed when she asked for a judgment of acquittal, which would be for a different court at a different point in time.
So in your opinion, how should the state have charged this?
One of two ways. Count one, as written. Alternatively, count two, knowingly intended to possess cocaine, but under 2A is legally responsible for whatever you possess. If your intent is to possess an illegal drug, then you're on the hook for whatever illegal drug you have, whether it's what you thought it was.
Well, it's different than the lower ecstasy, Mr. Barry, been a long time.
Yeah, long time.
That's how the judge instructed the jury, right?
That is how the judge instructed the jury.
So you think the instruction the judge gave was accurate?
What the judge instructed them in was accurate, except for see what happened, once they got past this JOA argument, and it may be an argument for the defense attorney being caught flat-footed as opposed to being as clever as I'm trying to credit her as being. But once the JOA argument failed, the better practice again would have been to object to that instruction because it would not be properly given on this information as charged. And this is just classic back to what is the first thing an attorney does when they prepare their case for a trial, for potential trial, is look at a charging document. Is there errors in a charging document? One, I think I cited the Stang case where the state had filed a statement of particulars that said it was on one day, and the defense or evidence at trial produced said it didn't happen on that day, and that's our defense. And the Florida Supreme Court said you get to do that. There may be, there's a scenario where this court could rule for me and say it's not, JOA should have been granted, but it doesn't prevent a double jeopardy. There's not a double jeopardy bar to charging it the right way and pursuing that. That would be something to litigate. I don't want to concede the point because it's really not germane to this discussion, how to salvage the state's case or save them from themselves. But that argument exists for the state because they didn't charge it the way they were supposed to. And in fact, there's an incongruity between the written language of the information, which is the record of 23. They talk about did knowingly sell, purchase, manufacture, deliver, blah, 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 heroin, as described in 893.031B, which oddly enough is the cocaine statute, or 2A, which is the statute that we're talking about that sort of transfers intent from, if I think I'm bringing cocaine into the state or into the country and it turns out to be heroin, I'm just as guilty. But again, the problem is you have to charge that. And that's
Do you have to charge it though? It explicitly states, the statute explicitly states that it's not a defense to do that. To say, I thought it was cocaine, but it ended up to be heroin, so therefore I'm not guilty of anything. Does the knowledge element not go to the illicit substance? So they would have to amend the information based on whatever the defense is, even though it's statutorily not, it's not a legal defense.
Well, and I think I'm saying the Thatch case, the Florida Supreme Court case from a couple of years ago, talks about the, being allowed to amend at JOA time if you want to, and that I suppose would have been available to the state in this case. But why would they need to? There's
my issue. I'm not seeing, I guess I'm not understanding if you're splitting out, that's why I'm asking, what does the knowledge element go to? The knowledge of what? I understand what the information says, but if it's not a defense to say, I knew it was coke, but it wasn't heroin, how does that matter if it's still an illicit substance and it's not a statutorily it cannot be a defense?
My argument is this, to address your question, if I don't do a good enough job, have another stab at it, but here's what I argue. In any case where this kind of thing comes up, the state puts me on notice as the attorney of the exact theory upon which they're basing their prosecution. So I'm on notice based on what they wrote and swore to here. And, you know, there may be discovery that's in conflict with that, but I would think as a hopefully a bright, person who graduated from law school, I'm going to make that argument. For example, in the Stang case, where it's, no particulars in the conflict between the date charge and the actual date, I get to make that my defense. And I may be on notice, the fact that I'm on notice of it happening on a different date informs my defense decisions. It doesn't, otherwise, to say that, well, I'm on notice because the law and discovery, if you look at it all as a whole, then you know that they can get around this problem. Not when they file one of these. They limit themselves. It is a limiting principle, or it is, or they mean nothing. If informations mean nothing and they don't put me on notice of anything, and the state can just give me a bunch of discovery and say, here, you figure it out for yourself, which is almost a status quo for discovery these days, then informations and indictments mean nothing. My position is you get to hold their feet to the fire on this. You get to point out and make that argument. I would have been much more aggressive about it than she was. And again, there's a universe out there where she may think that she may not have thought about this at all. She may not have that may have caught her completely off guard that, oh my God, there's, not only is a statute, but the judge, I think, cited a case that said Johnson or whatever the case was, that said, you can prosecute it that way. But every case begins with a charging document. The first thing the judge reads to the jury is the charge against the defendant. And that's how jury selection commences. That is the basis upon which we litigate our cases. And I understand that they're allowed to amend beyond I'm not making the rules, but they get to amend almost at any point in time prior to the jury going out to deliberate.
And
They didn't even bother to do that here.
And you believe that's required irrespective of the fact that the stated defense is statutorily prohibited. It doesn't mean anything, essentially. They're saying that doesn't save you from the charge. So the other cases you mentioned, I understand what you're saying, that you're held to the information, and I understand that. I guess my issue is the statutory constraint. You don't think that has any impact on the charging document, on the requirements and the information, is that correct? Even though it's not a legal defense.
It becomes a legal defense if they don't plead that that's their theory of prosecution in the charging document. That makes it a legal defense. They are abandoning that theory. And I've gotten away with this argument in some trials over the years. And by locking them in, getting up and, like I said, I would have been more aggressive about it. I would have announced it in an opening statement. And I would have pounded on through the defendant's statement.
When was the first time it was raised in this trial?
At JOA.
Not one time before that was,
Not
nor
before.
the state alerted to the problem.
No, and it's not my, other than once jeopardy attaches, then I don't mind announcing it, but I'm not going to call them up and say, or send a motion to, clarify, or, hey guys, you really got a problem in the way you pled this. That's not my job. And I will never be in the business of telling the state how to prosecute my clients or helping them out. Other than I did give an alternative theory of how to plead to one of your questions a moment ago. I think I'm about at the end of my time. You have any other questions?
In regards to the state's argument, they cite to, I think, the Gartrell case, stating that knowledge of possession may be inferred from the defendant's exclusive possession of the substance. So, notwithstanding your argument, here's he was in exclusive possession of this heroin. Why can't the court, or why can't the jury, or why can't we infer that he knew it was heroin, even though he might say it's cocaine? Why can't we infer that from that exclusive possession?
again, I just keep going back to the charging document and the way they stated what they're charging. Actually, even in opening statement, the state said you could find them guilty of possession of cocaine, interestingly enough. Probably a flub by maybe force of habit, but opening statement at transcript page 159. So, just as, I think the courts, I think the law is very strict on what constitutes waiver when it applies to defense attorneys and defense on appeal, and if, preserving a jury challenge is X number of steps you got to go through to preserve that. The state waived whatever theory of prosecution your question invites by the way they charge the case.
They charged it trafficking in heroin. He had heroin. He was in exclusive possession of it, so why couldn't we infer that he had knowledge that it was heroin? And I'm asking, that's what the state's argument was in this case, one of the arguments in their answer brief.
I can't do anything other than repeat what I've already said. It may be an unsatisfactory answer. It may again invite the
You're into your vote.
I am. You may have put your finger on what may end up being a 3850 motion. I appreciate your time. Thank you.
Anything from the state?
Good morning, may it please the court. My name is Tabitha Mills and I represent the state of Florida appellee in today's case. Taking the evidence in the light most favorable to the state presented competent substantial evidence of all of the essential elements of trafficking in heroin. Knowledge and intent are rarely an appropriate basis to grant an appellant's motion for judgment of acquittal. And further, Florida Statute 893.135 subsection 2 precludes as a defense the argument that a defendant thought he or she was in possession or trafficking in one substance as opposed to trafficking in another, any of the enumerated substances in subsection 1. And also knowledge as to the illicit nature of a controlled substance is not an essential element of the charge of trafficking in heroin and is instead an affirmative defense to that. So we're here on the judgment of the trial court's denial of the judgment of acquittal. If the court has any questions as to the issue as it's brief, I would entertain those now.
Did you plead specifically subsection 2 on the information?
Subsection 2 is not included in the information.
Did you need to?
No, because the knowledge as to the illicit substance is not an essential element that needs to be charged in the information. And the state would just point out that the information as being insufficient, there was no motion to dismiss, no motion to strike during the trial court, and in the initial brief, the appellant does not argue. He presents this argument as a denial of a motion for judgment of acquittal, not so much as an insufficient information. While in the answer brief, the state does.
So you're saying that the argument wasn't preserved?
The argument, I don't know. The argument was not preserved in the lower court.
It was raised and argued below, correct?
So they raised in the JOA that the state failed to present evidence that there was knowledge of possession of heroin as charged in the information, but I don't think there's an explicit objection raised as to the information as charged, saying that the information itself was insufficient. So the state would argue that that argument was not preserved, and that argument is also not.
Do you have legal authority in your brief? I didn't see any that said that the defense had to move to strike the information.
Your Honor, and I apologize, I didn't write the answer brief.
I saw it mentioned, I just didn't see any specific legal authority. Is there any specific legal authority that requires them to do that other than raising it as an argument?
I don't believe that we cited any specific authority that said raising it as they did in the judgment of acquittal during the judgment of acquittal argument either was insufficient in order to preserve this issue. We did argue that the issue was not preserved, and argued that that appellant did not argue fundamental error in his brief, thereby waiving that argument. I don't want to belabor the issue too long. If there's no other questions,
I just have one other one that Mr. Berry raised. Why mention an opening statement if you're trying to prove trafficking in heroin that I believe the statement was Mr. Krenza is guilty of trafficking in cocaine? Was that a misstatement by the state in its opening statement?
Your Honor, I apologize that I don't specifically remember that exact statement, but if it was raised, I would assume that it was a misstatement, as all the evidence presented was that he was actually trafficking in heroin, and despite the belief that the appellant believed that he was in possession of cocaine, that still isn't a defense to the alleged charge. The jury was instructed on trafficking in heroin with the subsection 2 instruction, which provides that even if he was in possession of, or thought he was in possession of cocaine, but actually possessed heroin, that's still not a defense. If there are no other questions, then I would rely on the record and our brief and ask that you affirm the judgment and sentence in all respects. Thank you.
Your Honor, just briefly, Judge Boatwright, you asked the state, especially maybe a good lesson for all day students attending this. You asked a question about whether subsection 2 was referenced in, as an officer of the court, it was referencing the information, 893.03.2A is referenced. So I don't want you to think that it wasn't. Kind of a duty to let you know that. My quibble with it, though, is it is just part of the language that says the knowing actual possession, etc., of heroin as described in 893.1B, which actually is the cocaine statute, or 2A, which doesn't describe anything. It is, as you were pointing out, the statute that says, you know, if you're, we don't care what you think you're possessing. If you possess the wrong, you know, an illegal drug, you possess an illegal drug. And so they do that, but they only use it as in terms of describing heroin. So I didn't want that to go uncorrected. And again, as to the issues of motions to dismiss, I think I'm not in the business of telling you if I'm happy with the charging document. Not really much reason for me to call the state attorney or file a motion that says, hey, this charging document is going to cause you some real headaches at trial. I'm never going to do that. And I do appreciate your time again. Thank you.
Can I ask one thing?
Sure.
What do you make of the state's argument that knowledge of the illicit substance is not an essential element?
They made it an essential element by pleading it.
By including it in the information, you mean?
Yep. It's what opens the door to the court's jurisdiction and informs their theory of prosecution. This is what tells me what the case is about.
They don't have to prove it as not an essential element, whether it's in the information or not. How does that make it an element of the crime just because they put it in the information? Does the statute tell us what the elements are?
Again, it may inform a 3850 motion, but I would argue that they made it an element and they have to prove it. So I would, maybe another way of perfecting this issue beyond merely asking for a JOA would have been to ask for a jury instruction on that one. But admittedly, that wasn't done. Thank you all very much.
Thank you, Mr. Baird. Thank you to both of you. Well argued case. And